This micro talk is part of a mini-series on the FINRA Notice on private placements. We encourage you to review the entire mini-series available on our free writings and perspectives blog. Thank you. Reg BI care obligations also include customer-specific obligations. This means that a member and associated persons must exercise reasonable diligence, care, and skill to have a reasonable basis to believe that a recommendation is in the best interest of a particular customer based on the customer's investment profile and the potential risks, rewards, and costs associated with the recommendation. And that recommendation does not place the financial or other interests of the member or associated person ahead of the interests of the customer. Members and associated persons should apply heightened scrutiny to whether a risky or complex product is in a retail customer's best interest. For example, they should consider whether a customer has an identified investor-specific trading objective that is consistent with the product's description in its offering documents, and or whether the customer has the ability to withstand the heightened risk of financial loss. Members and associated persons are well advised to consider lower risk or less complex options that can achieve the same investment objectives. The notice touches on other components of Reg BI, including the disclosure obligation, which requires members and firms to provide full and fair disclosure of material facts prior to or at the time of the recommendation. So material facts can relate to the capacity in which the broker is acting, material fees and costs, or the type and scope of services being provided. Keep in mind the disclosure of conflicts of interest alone does not satisfy the obligation to act in the retail customer's best interests. The notice also speaks to the conflict of interest obligation, which requires not only identification, but in most instances, efforts to mitigate or eliminate a conflict of interest. There are conflicts of interest inherent in any recommendation of securities based on the potential or actual receipt of compensation, revenue, or other benefits. Firms need to have a process to address conflicts of interest. It should not be a check-the-box exercise, but rather a more robust, ongoing process that's tailored to the specific conflicts that are potentially present. Conflicts may be of a particular concern when members recommend private placements of securities issued by an affiliated company. And then finally, the notice speaks to the compliance obligation. The compliance obligation relates to a member's responsibility to establish, maintain, and enforce policies and procedures reasonably designed to achieve compliance with Reg BI. Among other things, the FINRA notice recommends documenting the process or the reasoning behind particular recommendations. With respect to complex or risky products, it advises developing or considering developing procedures outlining the due diligence process for those products to ensure that they're assessed by qualified and experienced personnel. They also recommend appropriate training and supervision to help personnel understand the features, risks, and costs of these products. I encourage you to review the notice in its entirety. I also encourage you to visit Mayor Brown's free writings and perspectives blog for additional information on this topic and other regulatory developments. Thank you for your time.